Lawyers representing the 120 City of Johannesburg employees set to lose their jobs are about to outline representations made to the city last Friday and plan to institute legal proceedings against the city. The city says the fixed-term positions were irregularly converted to permanent posts. The contracts came to an end at the end of April. The lawyers are joined by Municipal Workers Union SAMWU. We cross live to that briefing now.
Friday, the 11th of March 2022, we made the said representations which inter alia covered the following points. And in doing so, I'll just give a brief background of the regulatory framework that revolves around this particular issue. And in particular, the Municipal Structures Act, the Municipal Systems Act, and the Promotion of Administrative Justice Act, PAJA. The premise of our client's legal argument in this matter is founded on Section 59 of the Municipal Systems Act, which indicates that the council, and by council we refer to the city's council, has the power to develop a system of delegations that will maximize the administrative and operational efficiency of the municipality. Furthermore, it states that the council can delegate every power except a power mentioned in Section 160, subsection 2 of the Constitution. Section 59, subsection 3A indicates that the delegated power may be varied or revoked subject to any rights that may have accrued to a person, and this is our emphasis. Our clients are employed as administrative support staff in the public office bearers' offices. They are mostly non-middle, senior or executive managers within these offices. They occupy positions from level 5, assistant director, to level 11, which is semi-skilled employees. Considered through an objective lens, it is clear that these positions have no influence in the strategic decision-making within the city or the public bearers' office, and they therefore can never stultify any operations of the new political administration within the city of Joburg, as has been alleged. It is tried that the Constitution of the Republic of South Africa is the repository of all state power, and that power is distributed by the Constitution directly and indirectly among the various institutions of state and other public bodies and functionaries. The exercise of public power is subject to inherent constitutional constraint, if only for legality, which is the exception, the extent of which varies according to the nature of the power that is being exercised. PAJA, read with the provisions of Section 33 of the Constitution, states that everyone has a right to administrative action that is lawful, reasonable and procedurally fair. Everyone whose rights have been adversely affected by an administrative action has the right to be given written reasons. Now I'd like to give a bit of a synoptic background which has led to the events that has brought us here today. On the 24th of April 2012, at a meeting of the Municipal City Council of the City of Joburg, it was resolved that the council delegates the authority in terms of Section 59 of the Municipal Systems Act, as I had alluded to earlier, to approve the staff establishment developed by the city manager in terms of Section 66 of the Municipal Systems Act to the executive mayor, subject to council approval of a policy framework within the delegation to be exercised. On 21 June 2012, the council had a further meeting wherein the following resolution was taken: that council delegate the approval of the staff establishment to the executive mayor. This power be exercised together with the mayoral committee as a power designated in terms of Section 63 of the Municipal Structures Act. The above power be exercised within the staff establishment policy framework and within the high-level design model as approved by Council on 25 August 2011 as may be amended from time to time, and within the annual budget as approved by Council annually. In accordance with the delegated authority granted at the meetings held on the 24th of April 2012 and 21st June 2012, various executive mayors under various erstwhile administrations of the city have since developed and amended staff establishments, including converting forms of employment to respond to changing priorities and to ensure a continuation of operational skills and knowledge under each change in the administration. During February 2021, the Mayor and the Mayoral Committee, exercising a power delegated by the 24th of April 2012 resolution and the 21st of June 2012 resolution, approved the conversion and placement of employees currently in political office on assistant director and lower levels, and converted to, or rather from fixed-term contracts to permanent employment. This resolution was implemented and all our clients were converted into permanent employment. I now wish to come to the notice that was issued on the 28th of February 2022. It is now common knowledge that the acting city manager issued the said notice to our clients premised on the extraordinary meeting of council that was convened on the 25th of February 2022, wherein the following resolution was taken: that the municipal council rescinds the decision of the mayoral committee to convert staff from contract to permanent in terms of section 59 of the Municipal Systems Act, and authorizes the city manager to give effect to this decision. The council further authorized the city manager to appoint an independent investigator to investigate the above processes of conversions of staff for possible irregularities and submit a report to the municipal council within 30 days. Our clients object to the decision contained in the said notice, and their objections are based on various procedural and substantive grounds. But more fundamentally, the notice and the intended conversion is tantamount to a termination of employment, and it is inimical to the object of Section 23 of the Constitution, read with Section 1 and 33 of the Constitution. The notice is further inconsistent with the rules of natural justice, and therefore it is inconsistent with the tenets of CAJA and the Labour Relations Act 66 of 1995. Furthermore, it is clear from the foregoing legal framework that the city ought to have first furnished the affected employees with a preliminary notice of its intention to rescind the decision to convert their employment contracts before presenting this matter to the City Council. We also find it strange and a bit irrational that the aforementioned decision of Council dated 22nd of February 2022 rescinds our client's appointment and directs an investigation into the conversion process after the fact. Any diligent and fair mayoral committee would have advised the Council to first investigate the impugned Council resolution. It is clear that inter alia, the investigation would have afforded the necessary audi alteram to our clients in order for them to give their point of view. Additionally, the notice of the conversion appears to be a fait accompli and with effect from a date that was not stipulated in the notice, and appears further in the city's directive that was issued on the 9th of March 2022, that our clients will no longer be permanent employees of the city. The city's conduct in this regard is inimical to the provisions of Section 3 of PAJA, read with Section 33 of the Constitution. The latter requires an organ of state to conduct itself in a procedurally fair manner to allow those that are adversely affected by a decision such as of a conversion of their employment to have an opportunity to interrogate the basis and the rationality of the decision. It is further clear from the notice that the city has failed to distinguish between the decision to convert the basis of the employment and the actual employment itself. The employment of our clients can never, as a matter of fact, be considered unlawful. The decision to convert the basis, on the other hand, can arguably be considered to be unlawful, which unlawfulness is denied. As a result, any possible contraventions of the Prevention and Combating of Corrupt Activities Act of 2004 can only be imputed to the decision to convert the employment, but not the employment itself. Our client's grounds for objection entail the following: that the city's notice has a number of procedural defects, which include a failure to call for representations and/or objections before the decision to rescind was taken. As indicated, the exercise of public power always has to be consistent with the rule of law, and where administrative decisions are taken, such administrative decisions have to be procedurally and substantively fair. As a result, all decisions taken by any organ of state exercising public power has to be compliant with Section 33 of the Constitution, read together with the provisions of PAJA, in particular Section 3 thereof. Section 3 requires the city, when deciding to take the decisions that adversely affect its employees, to adhere to a procedurally fair administrative process, which in the circumstances required not only adequate notice of the nature and purpose of the proposed administrative action, but a reasonable opportunity to make representations thereto. It also demands a clear statement of the administrative action, where the administrative action is to be implemented, as well as an indication of internal remedies in the form of appeals, if any. It is our client's case that the notice is defective, as the city seeks to make it seem as if there is another process that can be followed to safeguard our client's rights and interests, when a council resolution has effectively already been issued. The invitation contained in the notice is further irregular and disingenuous, as it is clear that the termination of our client's full-time employment was, after the unlawful council decision, a fait accompli.
All right, and so we come out of that briefing. My colleague Balenhle Mtetwa is following that story and will keep us updated. Nompumelelo Siziba standing by with your business, market and sports news at the top of the hour. It's good afternoon from me. Stay safe.